All rise. Yes, Ms. Burhill.
My Lords, in this appeal I represent the appellants, who are the defendants in these proceedings, and the respondents are represented by my learned friend, Mr. Tim Austin. This appeal is brought from the order of the 16th of June 2022 of Nicholas Caddick, KC, sitting as a judge of the IPEC, which gave effect to his judgment of the 20th of April 2022. The results of the claim below and the relief granted by the order of the 16th of June were that the claim for trademark infringement under Section 10.2 succeeded on the basis that there was a likelihood of confusion. The claim for trademark infringement under Section 10.3 succeeded on the basis that there was a link and that the appellants had obtained an unfair advantage. The claim for passing off succeeded. There was no honest concurrent use by the appellants. The appellants were ordered to pay the respondents the sum of £50,000 by way of costs, and the orders for the injunction and delivery up were stayed pending the final determination of this appeal. Permission to appeal was granted by my Lord Justice Arnold by his order of the 22nd of September 2022. And the grounds of appeal, which have been amended in red line to reflect my Lord's order, are in core bundle 1 behind tab 3, which I could perhaps ask your Lordships to turn up. So permission was granted on grounds 3C and 8 on the basis that those grounds have a real prospect of success. 3C deals with the absence of any evidence of actual confusion. Ground 8 is honest concurrent use. My Lord Justice Arnold was doubtful whether grounds 3D and 3E had a real prospect of success, but permission was nevertheless granted. Those deal with the characteristics of the average consumer and the differences between the parties' services. Permission was then given on grounds 5, 6B, 6C, and 7B to the extent that they replicate ground 3.
Yes.
So ground 5 deals with a link, and that replicates ground 3, the likelihood of confusion. Ground 6 is that when considering infringement under 10.3, the judge erred in finding that the defendants had taken unfair advantage of the marks. By B, erring in his assessment of the link, so that replicates ground 3, and C, erring in his finding that the defendants had obtained an advantage. Now 6C doesn't replicate ground 3, and I'm not pursuing it before my Lords.
Thank you.
Ground 7 deals with passing off, and the judge erred in his assessment of a misrepresentation, so that replicates ground 3. I'm not planning to address your Lordships separately on grounds 5 and 6 or 7 because they replicate ground 3. But if the appeal on ground 3 succeeds, it follows that the appeal on the other grounds succeed as well. Accordingly, my submissions will be divided into two halves. First, ground 3, likelihood of confusion. And second, ground 8, honest concurrent use. So starting with ground 3. Ground 3C is that the judge failed to place any weight on the absence of any evidence of actual confusion. When dealing with ground C, I'm going to divide my submissions into 4 broad topics. First, the standard of review on an appeal like this. Second, the relevant principles when considering the weight to attach to the absence of evidence of confusion. Third, I'll look at the judgment and identify the flaws in the judge's treatment of this issue. Fourth, I'll identify the findings the judge ought to have made had he not made the errors that he did. So the first topic is the standard of review. I acknowledge that the appeal on this ground is a challenge to an evaluative decision. And in respect of a challenge to a judge's evaluative decision, the correct approach to be adopted on appeal was summarised by this court in Sprint Room. That is in volume 1 of your authorities, behind tab 21. The relevant passages are sidelined and they start at page 569. 596
Yes.
of the bundle. So the basic point is that in a case involving an evaluative decision, the court must ask whether the judge was wrong as opposed to plainly wrong. My lords can see that over the page at paragraph 419 of IBM, which is quoted just at the bottom of page 597.
Mm-hmm.
And then over the page to page 598 of the bundle, the citation from the Supreme Court at paragraph 75 of the judgment. And then the conclusion that the court in Sprint Room drew is at paragraph 76 over the page. The key point is that on a challenge to an evaluative decision, the decision of the judge must be wrong by reason of some identifiable flaw in the judge's treatment of the question to be decided, such as a gap in logic, a lack of consistency, or a failure to take account of some material factor which undermines the cogency of the conclusion. And I will identify a number of flaws in the judge's treatment of this issue. Second topic, the legal principles relevant to the absence of evidence of actual confusion. The absence of actual confusion has a bearing on the question of whether there is a likelihood of confusion, but the weight of this factor varies from case to case. The relevant principles were set out in Jack Will's, which the judge cited in his judgment. My lords could turn up the judgment. It's in Core Bundle 1, behind tab 9. And if my lords could turn to page 121, paragraph 96, the judge cited the relevant passage from Jack Will's. As I've said in a number of judgments, absence of evidence of actual confusion is not necessarily fatal to a claim under Article 5.1b. The longer the use complained of has gone on in parallel with use of the trademark without such evidence emerging, however, the more significant it is. Other relevant factors are the scale of the use complained of and the likelihood of actual confusion being detected. So the weight to be attributed to the absence of evidence of actual confusion all depends on the circumstances of the case. And in particular, what opportunity has there been for confusion to occur? And what opportunity has there been for confusion to be detected? That brings me on to my third topic, which is the judgment. The judge dealt with this issue in paragraphs 95 to 100 of the judgment. I've already taken my lords to paragraph 96, where he cited the relevant passage from Jack Will's. He then referred to a number of other authorities, including at paragraph 86, Specsavers. And in particular, he cited a passage from that authority where the judge placed little weight on the absence of complaints about confusion from Asda customers, on the basis that for that route to have yielded relevant complaints, there would have to have been customers who were confused in the first place, who then had their confusion removed, and who then felt sufficiently strongly about it to complain formally to Asda. Then at paragraph 87, the judge cited Lord Justice Millett in Harrods, who said that the absence of such evidence may often be readily explained and is rarely decisive. And it's clear that the judge relied quite heavily on this, because in paragraph 98, he considered that the passages he had cited above show that the absence of evidence of confusion is rarely decisive, and that's to be contrasted with what my Lord Justice Arnold said in Jack Wills, that it's not necessarily fatal. The judge's findings... Are you
submitting that that's an error? This is all about evaluating evidence in a myriad of different contexts.
It is, my Lord.
And
I'm not submitting that he made an error of law.
No.
On this ground. So the judge's findings are at paragraphs 99 to 100.
Yes.
In paragraph 99, he recognised that Muzmatch had been trading since April 2011, but found that the absence of evidence of confusion is not because there was no relevant confusion, but rather reflects the fact that Matches and Muzmatch's services have been provided via their websites and more recently their apps. He then continued, where services are provided in that manner, then any other dealings are likely to be conducted via that same website or app and are likely to relate to the services that that customer had received via that website or app. On that basis, it's hard to see how or why any confusion would come to light. It would rarely be relevant to the customer's issues. Given this, it seems to me that despite the longer period of trading involved, this case falls squarely within the scope of what Manjay said in Specsavers. And that's a reference to why consumers, having been confused and then dispelled of their confusion, wouldn't complain about it. Now, in my submission, it's clear that he was here addressing himself to the question of what opportunity there had been for confusion to be detected. It's implicit in his judgment, and in particular his reference to the fact that Muzmatch had been trading since April 2011, that he assumed there had been an opportunity for confusion to occur. And on the question of what opportunity there had been for confusion to be detected, there are 6 identifiable flaws in the judge's approach and reasoning. The first flaw is that in considering that any dealings between the parties and their customers were likely to be via the same website or app, he ignored his earlier findings that both parties also promoted their respective businesses via social media. So at paragraph 39 of the judgment, which is on page 102 of the bundle, the judge found that the respondents promoted its business via social media. And just turning over the page, he found that as at October 2021, Match had 103,000 and 14,000 followers on their 2 Twitter handles. By October 2021, their YouTube channel had over 500,000 views. Meanwhile, in paragraph 55 and 56 of the judgment, the judge found that the appellants promoted themselves via social media, including organic and largely after 2017 paid for social media content. In fact, in paragraph 56, the judge referred to a single social media ad alone of the Appellants, which reached more than 100,000 users in the UK in February 2018. And the evidence from trial was that that was a Facebook post. Mm-hmm. There was also evidence before the judge that the respondents' customer care records were fed via their social media platforms. If I could take your lordships to Bundle S.
Is this still part of your first point?
Yes.
It is, yes. Yes.
Just before we look at that, can you, excuse my ignorance, tell me what organic social media content is?
That means not paid for.
You generate yourself?
Yes.
Yes, thank you.
Or your users.
Or your users, yes. So we were in Bundle S, behind tab 25. This is the respondent's disclosure statement. At the bottom of the page in the box, this confirms that the databases of customer care records that the respondents searched were fed via web desktop, app, and Twitter. So in the case of the respondents, their customers used Twitter as a platform for providing feedback, which is stored in the databases that they searched. In my submission, had the judge taken into account his earlier findings, as he should, he would have found that dealings between the parties and their customers were just as likely to have been conducted via their social media platforms. The second flaw is that he failed to place any significance at all on Mr. Eunice's evidence, which was unchallenged, that Muzmatch had in the past been contacted by customers of Minder. Minder was another provider of dating services in relation to matters concerning Minder's services. The judge dealt with this point in paragraph 100 of his judgment, and he dismissed it on the basis that he had no evidence as to how Minder operated. And that led him to conclude in the final sentence of paragraph 100, I do not think this evidence helps me in considering the likelihood of confusion arising from two businesses like Match and Muzmatch that are using similar names. And that conclusion was based on a failure to appreciate the relevance of the Minder evidence. I'm going to take your lordships to the relevant evidence, which, as I've already said, was unchallenged. It's in Bundle S, behind tab 5, on page 82. And if I could ask my lords to read paragraph 186. The relevance of this evidence was not in considering the likelihood of confusion as between Match and Muzmatch. It was relevant to the question of how instances of confusion in the online dating industry may come to light, billing and account inquiries, the route by which it comes to light, via contact made with the customer support team, and where such confusion exists, how it is detected by the appellants. The customer support team notify Mr. Yunus. It was therefore evidence of how instances of confusion, were they to exist in this case, may have been detected. And in my submission, that was a material factor which the judge wrongly failed to take into account.
Can I ask you, this is evidence of people who in fact used Minder contacting Muzmatch, presumably in the belief that Minder was related to Muzmatch. The confusion the judge found was people thinking that Muzmatch was economically linked or in some way connected to Match. So if there'd been confusion, we would expect users of Muzmatch to contact Match. Is that right?
Yes.
It's less likely to work the other way around. It's less likely that people who used Match would think to contact Muzmatch if they had a problem.
Well, I'm not sure that necessarily follows, for this reason. The judge found that consumers would believe that Muzmatch was a sub-brand of Match. And if that were the case, one might well imagine a situation where a consumer came to Muzmatch, having already used Match, and said something along the lines of, I've been using your mainstream dating service, but now I want to try your more specialist one.
Okay, yes, thank you.
The third flaw concerns the way that the judge dealt with the second instance of purported confusion relied upon by the respondents. That instance concerned a billing inquiry that had been made in the States. It's related to the submissions I've just made. It was dealt with by the judge in paragraph 103, but in the context of evidence of actual confusion. And my lords can see from that paragraph of the judgment, it's on page 123, bundle, that this instance involved a consumer in the US who used both parties' services and complained to Match.com by mistake about a $20 charge levied by Muzmatch. The judge found that the fact that a customer made a mistake in the US shows that there's a likelihood of such confusion arising in similar circumstances in the UK. Now, although he said he wasn't placing too much reliance on this, to the extent he placed any reliance on it in finding a likelihood of confusion existed in the UK, he was wrong to do so because there was no evidence concerning the circumstances of use in the US. However, this evidence was relevant to the question of how confusion, were it to exist in the UK, would be detected by parties operating solely online, and these parties specifically. But the judge failed to take this into account when considering in 99 the opportunity for confusion to be detected. This evidence also supported the appellant's submission that was made at trial, that where customers use 2 or 3 different online dating platforms, it's likely that confused consumers would have mistakenly contacted one or other of them. But the judge dismissed this point in paragraph 99 without undertaking any further analysis of this submission and without considering this particular piece of evidence in this context. The fourth flaw is that the judge failed to take into account the unchallenged evidence of Mr. Yunus that the appellants have a reporting function whereby users are encouraged to contact Muzmatch customer support directly or use the in-app reporting function. The judge did make passing reference to this evidence when he set out the background facts. So at paragraph 46B of the judgment, which is on page 104, sorry, 46C at the bottom of page 104, he referred to the fact that in September 2021 alone, some 3,915 reports were filed by users of Muzmatch, which resulted in 570 accounts being blocked. But he then didn't take this into account when considering whether there was the opportunity for confusion to be detected. At trial, the respondents relied on the number of complaints the appellants had received from users of their service. There were millions and millions of customer reports that were filed in this case, which the appellants monitor as part of their business. And if there was a likelihood of confusion, one would expect at least some of those complaints to have found their way to the wrong person. For example, you're not taking this seriously, I'm going to go to Match.com instead. Perhaps I could just show my lords some of these customer reports. They're in bundle S, behind tab 21. On page 276 of the bundle. So these are all reports filed by Muzmatch customers. And my lords can see halfway down the page, taking _break. Just need a break. It's a match app, so I don't think people should be able to hide their pictures. One might imagine a comment, you haven't got this feature on Match.com, so why do you have it here? Then at the bottom of the page, thanks to you guys, I've been connected to a great individual and God willing, found my perfect match. Once again, thank you. Then turning over to page 281, right at the top of the page, does not feel halal and not real people on the app. Met someone on Match.com. Now that's an example of a consumer distinguishing between Muzmatch and Match.com. Then over the page onto 282, I'm just going to do one more of these. About halfway down, met on Muzmatch, planning our wedding. And then just underneath that, MM, that's a reference to Muzmatch, are doing a great job in providing a halal platform for introductions. Keep it up. One might imagine a comment, Match.com are providing a great Muslim offering. So these customer reports and the sheer volume of reports that are filed was a material factor which the judge wrongly failed to take into account when considering the opportunity for confusion to be detected. Fifth flaw was that he was wrong to consider that confusion would not come to light because it would rarely be relevant to the customer's issues. In my submission, he was led into this error because he ignored the evidence I've just discussed. So the US billing inquiry sent to Match by mistake, Minder users contacting Muzmatch by mistake about account queries, and the customer reports. But it's also because he relied upon Specsavers. And we can see that he placed emphasis on what Mr. Justice Mann said in Specsavers in the last sentence of his paragraph 99, where he said, "It seems to me that despite the longer period of trading involved, this case falls squarely within the scope of what Mann J said in Specsavers as set out above." So that's a reference to consumers being confused, dispelled of their confusion, and then feeling strongly about it to complain. In my submission, this was a clear gap in logic, because detecting confusion in a case like this doesn't rely solely upon consumers making a complaint about the fact that they were confused. One might well imagine a situation where if a consumer thought that Muzmatch was something to do with Match, a sub-brand, for example, they posted a comment on social media or a tweet along the lines of, "I'm a loyal user. Will you offer me a package if I use Tinder, Match.com, and Muzmatch?" That's just an example. This was quite unlike the situation in Specsavers. In that case, Asda had relied upon the absence of complaints about confusion, despite the 6 months that the logo had been present in their stores to the date of trial. And the judge simply concluded that it was unlikely that customers would have felt sufficiently strongly about their confusion to complain about it. There are two key factual differences between this case and Specsavers. The first is that Specsavers didn't concern online businesses, so it's unclear and unexplained by the judge why particular facts explaining the absence of actual confusion in that context would apply to this different context. Secondly, Specsavers didn't have any customer feedback loop. Unlike Match.com, who we know searched millions of customer feedback records, and Muzmatch, which had a reporting function, and they monitored the reports that were filed. That then leads me to the sixth and final flaw. And that is that the judge failed to place any real weight on the very extensive disclosure exercise undertaken by the parties in this case. He was led into that area because he considered that confusion would be rarely relevant to the customer's issues, so simply wouldn't come to light. And that's wrong for the reasons I've already discussed. Had he not made those erroneous findings, he would then have considered the significance of the disclosure exercise in this case. He made a passing reference to it in a footnote. It's footnote 10 on page 121. But its relevance cannot be understated. In this case, the disclosure exercise was extensive. Between them, the parties searched more than 53.7 million records using 17 keywords. If I could take your lordships to the Respondent's third Part 18 response, which is in Bundle S.
Just before you do, could you
Yes.
at least summarise for my benefit the the broad nature of the records, just so that I understand the extent to which both electronic records and social media records were searched. Because I understand your point to be that it's different from Specsavers because it's not just a matter of complaining. There are millions of people talking about this in different environments, and you would, I think your submission is, you would expect to pick up from that if there were any real confusion. But what I don't have a clear understanding of, and forgive me if it's entirely my fault, is the sort of buckets of different types of things that were being searched.
Yes. So in this case, the parties undertook electronic searches of databases.
Yes.
So as regards Match.com, they searched through, I believe, 4 databases. And my lords will recall the disclosure statement, which confirmed that that was fed via the web, the app, and their Twitter feedback. If my lords could take out bundle S behind tab 26.
Yep.
This is the respondents' third part 18 response, in which they confirmed the extent of their search by reference to the number of customer care records that were stored in their 4 databases. And my lords can see under response 1A, the Accio database contained approximately 9.8 million unique messages, and they searched the entire database for efficiency. Then B, the EasyWare database, contained approximately 710,000 tickets. C, the customer care tickets for Match US contained 16.2 million tickets. And D, they also searched the Tinder database, which contained 18.1 million tickets. So in total, they searched around 44.8 million records, trying to find instances of confusion. Then in terms of the appellant's search, if my lords turn back to tab 5 of that bundle, on page 62, Mr. Yunus dealt with the extent of the search at paragraph 109. As I set out in Muzmatch's disclosure statement, at the time when the customer reports database was searched, it contained 17 million records in total and almost 8 million records from UK members. And then he gives the figures for the other 2 databases that were searched. Then my lords turn on to page 81 of that bundle and look at paragraph 182. The defendants applied 17 different keyword search terms to those databases, which yielded 2,911 responsive documents. No evidence of confusion. Then at paragraph 183, as a result of a complaint from the respondents, the appellants then applied the word match alone as a search term, and that resulted in 43,000 documents, of which 4,000 documents were reviewed by my instructing solicitors. The bulk of those were disclosed to the respondents. 3,811 documents were disclosed. Paragraph 184, none of the documents reviewed showed any evidence of consumers having been deceived or confused. And then paragraph 185, Mr. Yunus confirmed that he had never come across instances of confusion, and as part of his disclosure search, he asked his customer support team, who monitor the reports on a daily basis, whether they'd ever seen user feedback suggesting confusion, and they confirmed that they hadn't. So the short but significant point is that these were highly motivated parties who adopted a no stone unturned approach to finding instances of confusion, and yet none were found. In my submission, the learned judge's finding that the absence of evidence of actual confusion was not because there was no relevant confusion was wrong, which he made because he ignored a number of highly material factors.
Was all this drawn to his attention? I appreciate
Yes.
that you were under quite a lot of time pressure.
Yes, my lord, it was. It was in my written submissions, and I made the submission orally as well. And my lord will recall in the footnote the judge refers to the number of records that were searched.
Just on that point,
Yes.
in your skeleton argument, you rely upon what I said in the Glaxo case about using social media for this purpose. Was that drawn to the judge's attention?
Glaxo was not drawn to the judge's attention.
Thank
no.
you.
The fourth topic is what the judge ought to have found had he not made the errors that he did. And in my submission, he would have made 3 express findings. The first was that there was ample opportunity for confusion to occur given the side-by-side trading of the parties for a period of 10 years. Now, I think that's implicit in his judgment at paragraph 99, but I want to address it now because it's also relevant to the question of honest concurrent use, which I'm going to come on to deal with. And I'm going to do this by reference to findings that the judge made. In paragraph 95, the judge found that Muzmatch had been trading since 2011, and then at 99 he found that they'd been trading on a large scale since after 2016. At paragraph 55 of the judgment, he found that by February 2015, the Muzmatch website had 8,122 users in the UK, and there had been some 1.5 million views of pages from its website. Also in paragraph 55, during this time, until February 2015, the Muzmatch name or logo was used not only on the website, but in marketing and promotional materials. So the judge referred to organic social media content, word of mouth, leaflets and business cards. Then in paragraph 56 of the judgment, we found that there was a more rapid growth after the switch to the app in March 2015. There were 7,824 sign-ups in March 2016, generating some 25.8 million online swipes in the UK. That had increased by September 2021 to around 666,000 sign-ups and an average of 71 million swipes. I've already referred to the use in social media, the ad that reached over 100,000 people in the UK in February 2018. So, ample opportunity for confusion to occur. The second finding he ought to have made is that there was ample opportunity for confusion to be detected. and that is by virtue of both parties' presence on social media and the feedback received via those platforms, the reporting system that was put in place by the appellants, the volume of reports filed, and the monitoring of those reports by the customer support team. The fact that customers use more than one dating app at a time, and indeed in this case, customers used both the claimants and the defendants' services. And finally, detecting confusion in the online dating industry simply doesn't depend on consumers complaining about being confused. It can be detected via other ordinary communications with consumers. For example, queries about billing issues, as demonstrated by the US example, or comments posted on social media. And then the third finding the judge ought to have made was that if there had been confusion in this case, given the no stone unturned approach adopted by the parties to disclosure, they would have found it. In conclusion, the learned judge ought to have found that there was no evidence of actual confusion because there was no likelihood of confusion, and dismissed the claim under section 10.2 accordingly. It follows that the claim under section 10.3 and the claim for passing off ought also to have been dismissed on the basis that there was no link and no misrepresentation.
Well, that's obviously correct so far as passing off is concerned, but why do you say that an absence of likelihood of confusion for the purposes of section 10.2 necessarily equates to an absence of a link for the purposes of 10.3?
Because in paragraph 115 of his judgment, the judge found that the factors that led him to reach the conclusion on likelihood of confusion also led him to reach the conclusion on a link. So he relied on the same factors. It's page 125 of the judgment.
Yes, thank you.
I would stress to this court that these three express findings that I say the judge ought to have made are open to this court to make because they don't require a fresh assessment of the evidence, and they don't require this court to make additional findings of fact. What it requires this court to do is reevaluate the facts as already found by the judge. Unless my lords have any questions, those are my submissions on ground 3C.
No, thank you.
I'm going to deal with grounds 3D and 3E very briefly. Ground 3D is that the learned judge failed to take into account the characteristics of the average consumer when making the global assessment. And in particular, he had found in paragraph 76 that the level of attention paid by the average consumer of dating services is likely to be higher than for normal consumer items. And that's all to do with the significant amount of personal information that has to be imparted and the need to trust the platform that the consumer is providing that information to. And although the judge undertook the global assessment from the perspective of the average consumer, he did not take into account his earlier finding as to the higher level of attention that would be paid by the average consumer, and he was wrong not to do so. Ground 3E.
Just before we leave it, and that follows through precisely how to your broad submission, had he taken it into account?
Well, it's part of the global assessment that the court undertakes for a likelihood of confusion.
Yeah.
So the more attention that the average consumer is paying, the less likely they are to be confused.
You say it's an error of principle which requires and entitles this court to undertake the global assessment again.
To do. Ground 3E is that the judge failed to take into account the differences between the appellant services, which were aimed at the Muslim community, and the respondent services, which were generalist services not targeted at any particular class or type of person. And the very short point is that this was important context against which the likelihood of confusion should have been assessed.
Can you help me? I mean, the question of context is a vexed one, as we know. What exactly do you mean when you say that it's important context in the present case?
I mean that the differences in those services arising out of the targeting in the case of the appellants and the non-targeting in the case of the respondents was context in which the likelihood of confusion ought to have been assessed. It amounted in practice to a point of difference which weighs against a finding of a likelihood of confusion.
But what I'm struggling with is that at first blush this appears to be a submission about the extent to which the services are similar. But the judge has made his assessment on similarity of services, as there's no challenge to that. So once he's reached his conclusion on the degree of similarity of the services, how is there something else that he's failed to take into account?
Well, my lord, as I started this submission, it is a very short point. And the simple point is just that it forms part of the overall context which ought to have been taken into account. I don't think I need to say any more about that ground.
All right, thank you.
Before I move on to ground 8, honest concurrent use. I'm going to divide my submissions into 4 broad topics. First, the legal principles relevant to the modern doctrine of honest concurrent use. Second, the judgment, and I'll identify the 2 errors of law that the judge made. Third, I'll explain the effect of those errors. And fourth, I'll look at the question of honesty, and in doing so, I'll address the points raised in the respondent's notice. So starting with the relevant legal principles.
Yeah, just before you get into the detail,
Yes.
Can we orient ourselves by having a headline submission from you as to whether it is your case that this is indeed, as appears to be your submission in the skeleton argument, a freestanding defence? And secondly, at what point in time do you say this defence is to be assessed and on your case established?
Yes. So the starting point is that I agree with my learned friend that since the directive affected a complete harmonisation of the rules relating to the rights conferred by a trademark, the older national law statutory defences cannot apply. Now, the cases post-Budweiser, which is where the modern doctrine of honest concurrent use originates, continue to refer to it as the defence of honest concurrent use. And that's probably unhelpful for two reasons. Firstly, it's not a defence in the sense of the statutory defence that existed in the 1938 Act. Well, in fact, it originated in the 1905 Act and was carried forward to the 1938 Act. Secondly, it's unhelpful because that's what the old doctrine or defence was called. But the requirements of our modern doctrine are subtly different because the focus now, as coming through the CJEU, is on the functions of the mark and how those functions have been altered through coexistence. I can't see that it matters whether it's characterised as a specific defence or part of the infringement question, save possibly on 2 points. The first would be the burden of proof, and the second would be potentially the relevant date. Would it be helpful for my lords to be addressed on the burden of proof, because this is not something that's been covered in either Morty's skeleton?
Well, I certainly think that's a germane consideration, but take your own course as to when you think it's convenient to address that.
I'll address it now before moving on to the bulk of my submissions. So on the burden of proof, on a Section 10.1 case, it is clear from the case law that it is for the defendant to prove no effect on the functions of the mark. And that comes from the Supreme case, and it was also addressed in Walton Stores.
Yeah, to be clear, you mean Supreme Pet Foods?
Supreme Pet Foods,
yeah.
Yes.
Yeah.
And the reason that is so is because in a double identity case, a likelihood of confusion is assumed, and that is an effect on the origin function. So the burden then shifts to the defendant to establish no effect. It's not clear whether this is the same in a Section 10.2 and Section 3 case. There is no separate requirement in Section 10.2 and Section 10.3 for an effect on the function of the mark, but that's because an effect is subsumed within a likelihood of confusion or a link and one of the other forms of injury. It therefore follows that for the purpose of infringement under 10.2 and 10.3, the claimant bears the burden of showing an effect on the functions of the mark, which it does by establishing a likelihood of confusion or a link coupled with one of the forms of injury. So then in the case of honest concurrent use, it must be the case that the defendant always bears the burden of proving the concurrency of the use and the honesty of the use. But on the question of who bears the burden of showing an effect on the functions of the mark, or the lack thereof, I think the correct analysis is that the burden must initially be on the claimant, because the claimant bears the burden of establishing infringement. But once, or if, the claimant has established a prima facie case of infringement, the burden then shifts to the defendant to establish that there is no effect.
And is that an evidential burden or a legal burden? Or does it not matter?
I'm not sure that that matters.
That tends to suggest that in a 10.2 and 10.3 case, what the defendant's doing by advancing a defence of a contention of honest concurrent use is negativing the likelihood of confusion. But they're not entirely two sides of the same coin, are they? Because in Budweiser, this court, when it came back from a CJAU, said, well, there will be some confusion, but you just have to live with that.
That's right. And the existence of confusion does not preclude a defendant from relying on honest concurrent use.
So how does it work? I mean, we can see how it works in a 10-1 case because the CJAU dealt with that in Budweiser. Has the CJAU dealt with this European defence in a 10-2 or 10-3 case?
Not that I'm aware of. The Court of Appeal in IPC dealt with it in the context of 10-2. I'm not aware of a case where it's been dealt with in the context of 10-3.
Thank you.
Then the second way that characterising this as a defence or not might have an impact is on the relevant date. And my lord will have picked up my reference in the skeleton to the comments expressed obiter in W3 that honest concurrent use might be better viewed as a factor that falls into account as part of the global assessment. And we say that that's wrong to the extent that this means the assessment takes place at the same date as the assessment of infringement, being the date the use complained of commenced.
That I understand, but when is there what is the correct date, and is it your case that there's more than one relevant date?
Well, in my submission, logically, the relevant date cannot be the date of first use, because then there would be no concurrent use. The upshot of a lack of effect on the function of the mark is that this is something that happens through the education of the public over time. You simply can't make that assessment if there's one fixed point of assessment at the date of the first alleged infringement. It has to be a continual assessment. For example, activity that isn't likely to affect functions might later affect the functions, and vice versa. So in my submission, the relevant date for considering what effect there has been on the functions of the mark is the date of the claim form.
I'll be sure I've understood that. Trademark infringement is a tort. So you can sue for past torts, subject to limitation. So for the past 6 years, you can say you did infringe up to 6 years ago. Obviously, if you want to stop it going forward, you have to show it's still infringing at the date of trial. Why is the issue of the claim form the significant date? Why is it not for past use what the position was at the date that I complain of, and for future use as at the date of trial?
Well, so just dealing with my lord's point about 6 years before the date of the claim form, that's not completely irrational, but in my submission it is somewhat artificial in the context of honest concurrent use, because that date has no connection with the date that the use commenced, or the date that the use continued until, or the date when the claimant first complained about the use. If there's no honest concurrent use 6 years before the date of the claim form, because, for example, there's an effect on the functions of the mark, but by the date of the claim form there is, because there's no longer an effect, then that ought to be enough. Now, there might well be liability for damages in that situation going back 6 years, but there would be no infringement thereafter, with the result that a claimant would not be entitled to injunctive relief.
Yes, thank you.
I'll start with my first topic,
Thank you.
which is the relevant legal principles. The modern doctrine of honest concurrent use has its origins in the decision of the Court of Justice in Budweiser, which is in Volume 1, behind tab 8. If my lords could turn that up, please. This was a relative grounds case based on double identity. Picking it up at page 134 of the judgment, my lords will see the question that was referred, which is set out at the top of that page, subparagraph 3. And that question was then considered at paragraph 63 onwards. My lords could turn over to page 139 of the bundle. At paragraph 68, the court referred to the essential function of the mark, which is to guarantee the trademark as an indication of origin. Then at 69 and 70, the CJU noted that the conditions of application of Article 4.1a correspond essentially to Article 5.1a, that's the equivalent of our Section 10.1, such that the interpretation of Article 5.1a is also applicable to Article 4.1a. Then at paragraph 71, the court emphasised the nature of the exclusive right, which is to enable the trademark proprietor to protect his specific interests, that is, to ensure the trademark can fulfil its functions. Therefore, the exercise of that right must be reserved to cases in which another party's use of the sign affects or is liable to affect the functions of the trademark. Then at paragraph 74, my lords could read that and the emphasis that the court placed on having an adverse effect on the essential function of the mark. At paragraph 76, the court stressed that the circumstances which gave rise to this dispute were exceptional and listed out 5 reasons why that was so. The first reason at 77 referred to the period of concurrent use. The 4th reason was that consumers were well aware of the differences between the parties' respective products. And the 5th reason was that it follows from the coexistence of these 2 trademarks. Even though the marks were identical, the beers were clearly identifiable as being produced by different companies. And the Court of Justice then answered the question at paragraph 84 of the judgment. And if my lords could just read that paragraph.
So, what is your submission as to what date the Court of Justice has in mind there? I mean, given its registration, prima facie, it's the date of registration that they have in mind.
It's not made express, but that is certainly arguable. And obviously, in that case, the concurrent use predated. But of course, that was a relative grounds case. So that is slightly different to this situation where we're considering infringement.
Well, indeed, but as you've pointed out, the reasoning starts from the analysis in the infringement context. Now, you know, the two are not precise mirror images of each other. They're almost mirror images. particularly when it comes to double identity. But one of the potential differences is the question of date.
The Court of Justice didn't address the relevant date in this judgment.
Well, indeed they didn't, but what is your submission based upon what they did say as to the correct date?
My submission is that it wasn't dealt with by the Court of Justice in this case. And I'm not going to speculate on what date they may or may not have had in mind. I'm going to develop the relevant date point as we move through the authorities and look in particular at the way this has been interpreted in the UK.
All right, well, can I put some words into your mouth and see
Yes.
if you agree with me? Excuse me. Do I understand that your submission is that the date in the registration context doesn't matter for our purposes because this is an infringement case?
My submission is that the date was not considered by the Court of Justice in this case in the context of relative grounds. At the moment, I can't see how the relevant date for the purposes of relative grounds affects the question of when the position is considered in the context of infringement.
Sorry, can I just be sure I've understood what
Yes.
you mean by relative grounds? You mean where there's registration of two marks?
Yes.
And the question is, can the owner proprietor of the earlier mark object to the registration of a later mark?
Yes.
Is that what you mean?
Yes, this was an invalidity.
Yes.
Yes.
Yes. And if you look at 77 of the judgment, which you referred us to, the 30-year period, it's 30 years prior to the registration of the marks concerned.
Yes.
Presumably, at the time of the registration of a later mark that they're talking about there, so they're looking for a long period of honest concurrent use before registration. But that's, as you say, that's relevant to the relative grounds case, but it doesn't necessarily read across to infringement. Have I understood your submission correctly?
Yes. Just on the 30 years of use, of course, this was a case where the war between the parties had been going on for about 100 years. In fact, I think the use
Yes,
in
but
the
in
UK
the
was
UK
30
only
years.
since the early 70s.
Yes, that's right. And of course, these 5 reasons that are identified by the Court of Justice as making the case exceptional are always seized upon by a claimant faced with an honest concurrent use point. But it doesn't mean that the doctrine is confined to cases which share all of those characteristics. The key question is what effect the continuing use has had on the functions of the mark.
So it doesn't need to be 30 years. The question is whether it has or is liable to have an adverse effect on the essential function of a trademark.
Exactly, yes.
But it doesn't answer the question of the date at which you test that, because you say that it just wasn't an issue in that case.
Well, this case doesn't answer that.
Yes, yes.
And in fact, the subsequent cases have never really grappled with this issue of the relevant date. And that's because it does not form part of the law that the use has to be non-infringing from the outset, and so the point never arose. The reason this arises in this case is because the judge proceeded on the basis that for honest concurrent use to apply, the use had to start as non-infringing.
And you say that was an error.
We say that that's an error of law. So that's why the issue arises in this case, and it perhaps explains why the cases prior to this haven't grappled with this point.
Thank you.
If my lords could turn over to the Court of Appeal's judgment behind tab 9. page 146. So this is when the case returned to the Court of Appeal following the CJU's judgment. My Lords will see the summary of the appellant's submissions in paragraph 6, which the court went on to agree with. My Lords could read that. The respondents were running the point that honest concurrent use didn't apply. They could demonstrate an adverse effect on the basis that there was confusion. And that was dealt with and rejected by the Court of Appeal at paragraph 17 of the judgment on page 149, where Lord Justice Jacobs said, "I did not hold that the level of confusion was de minimis. I said it was small, not that it was negligible. The level of confusion in the earlier cases was clearly not negligible. Otherwise, the claims in passing off would have failed for that reason alone, not because there was a defence of honest concurrent use or failure to prove goodwill." Then over the page, at paragraphs 19 to 21, the Court of Appeal rejected the argument that honest concurrent use is limited to cases of de minimis confusion. And then the conclusion in 23 is that there was no impairment of the guarantee of origin of either side's mark. The guarantee is different given a situation of long established honest concurrent use. Then the next time the Court of Appeal considered honest concurrent use was in IPC, which is behind tab 15 of that bundle. In IPC, the claimant had published the Ideal Home magazine since 1920, and in 2009, the name Ideal Home was registered as a trademark. Also in 2009, IPC launched their online shop. Meanwhile, the defendant had run the Daily Mail Ideal Home exhibition since around 1908, but they changed the name in the 1990s to the Ideal Home Show. Then in 2012, which was 3 years after IPC's mark was registered, the defendant launched an online shop, and it was that activity that was complained of by IPC, resulting in proceedings for trademark infringement and passing off. This appeal was concerned with the infringement claim under section 10(2). If my Lords could turn to paragraph 38 of the judgment, which is on page 370. Lord Justice Kitchen in paragraph 38 referred to the essential function of the trademark, and then at 39 recognised that the origin function is liable to be adversely affected where there exists a likelihood of confusion. Then at paragraph 40, he identified the key issue on the appeal. It's inherent in these propositions that the impugned use must indeed be liable to have an adverse effect on the functions of the trademark in the circumstances of any particular case. And then the central issue on this appeal is whether or not the use by Media 10 of the name Ideal Home Show in relation to internet retail services is liable to have an adverse effect upon the functions of the registered mark in the light of the very many years during which the words Ideal Home have been used. The Court of Appeal reviewed the judgment in Budweiser. Don't need to go to all of that, but I would just ask your Lordships to read paragraph 48, noting the fundamental question to be asked and answered. And then in paragraph 51, the court agreed with the Court of Appeal in Budweiser regarding confusion. No doubt many consumers will recognise that the marks are used by different businesses, but others will not. In other words, once honest concurrent use is established, the mark does not solely indicate the goods or services of just one of the users. As Sir Robin Jacob explained, in such a case, the guarantee given by the mark is different. So it is quite clear, my lords, that the focus of the doctrine of honest concurrent use is on the effect the coexistence has had on the functions of the mark. If, as a result of the coexistence, there is no effect, then there is no infringement. But the crucial question is whether the impugned use does or does not have an effect upon the functions of the mark. Moving on to my second topic, which is the judgment. In my submission, the learned judge in this case erred in his application of the law in two specific ways. Firstly, he considered that honest concurrent use required the use complained of to be non-infringing from the outset. Secondly, he considered that honest concurrent use required the claimant's mark to have been registered after the honest concurrent user had started. The consequence of those two errors was that he failed to consider the key question, which was whether the impugned use does or does not have an effect on the functions of the claimant's trademark. If I could ask my lords to pick up the judgment at page 130. So the judge at paragraph 137 said that the concept had its roots in section 12 of the Trademarks Act 1938. He's there referring to the doctrine as it existed pre-Bud. And then in paragraph 138 he referred to Budweiser, IPEC and Victoria Plum. His key reasoning is set out in paragraphs 141 and 142. And he started that reasoning by saying that in cases like Budweiser and the other honest concurrent use cases relied upon, the use relied upon as being honest concurrent use seems not to have been infringing use when it started. Indeed, in each of them, the claimant's mark sued on was registered after, usually well after, the honest concurrent use had started. And then halfway down that paragraph, he said, in the absence of, say, estoppel or statutory acquiescence, it's difficult to see how use that starts as infringing use can be turned into honest use by the fact that it's continued. The very reason why use infringes is because, if left unchecked, its effect would be to educate the public that the mark does not indicate the services of the trademark proprietor. It must be a very unusual case where a defendant can argue that continuing to infringe gives rise to a defence to an infringement claim. Now, in my submission, that was framing the question completely incorrectly, and it also appears to be conflating infringing use with dishonest use. It's not that continuing to infringe gives rise to a defence. What gives rise to no liability is the continuing use, the coexistence, and the effect of that coexistence on the functions of the trademark. It's simply not a question of continuing to infringe, giving rise to a defence. It's a question of the period of coexistence educating the public in a way that alters the guarantee given by the mark, such that there's no longer any effect on the functions of that mark.
And your submission is that's true, even if the judge is right that the use initially, I think in this case in 2011, was infringing. There comes a stage at which, if the trademark proprietor does nothing about it, that honest concurrent use has educated the public so that the mark has a different function, and at that point it stops being infringing.
Yes.
Is that,
Yes.
that does have the consequence, doesn't it? The judge pointed out that what starts off as infringing use over time becomes non-infringing use. And I understand you don't like the way he puts it, but the consequence is the same.
Yes.
That if you allow it to carry on for long enough, then you can no longer complain of it because the public no longer sees the mark as designating simply the proprietors.
Yes. And there's nothing particularly startling or unfair about that, because the registration of a mark confers on the proprietor a very valuable monopoly, but that monopoly comes with responsibilities.
Vigilance is the lifeblood of a trademark.
And so in the same way that a mark might be lost through non-use, or because the proprietor allows it to be used generically, so too can that monopoly be altered if the proprietor stands back and does nothing whilst letting a third party use it. And the monopoly is altered because the guarantee provided by that mark has changed, with the result that the proprietor can no longer obtain an injunction restraining the future use of that mark by the concurrent user.
Yes, can I just ask you, there's another factor which bears upon this, which is, of course, we have a number of different registration dates in play. So the first EU TM has a date of 1st April 1996, but then the second one is as recently as 13th of January 2017.
Yes.
Moreover, in between the two, we've got the UK registration, 3rd of March 2015, which is also different in that it's supposedly a figurative mark, but in reality it's as close as can be to a registration of Match on its own, without even the .com.
Yes.
So how does all of that factor in?
Well, my lord, happily, on the facts of this case, that doesn't complicate the analysis. And that is because it is very clear from the judgment that the judge was analysing the question from the date of the appellant's first use in 2011. And one can see that very clearly in paragraph 141, where the judge said, in the present case, Muzmatch's use started as infringing use of Match's prior registered mark.
But of course, that can't be the case for the 2015 mark or the 2017 mark.
No, so the relevant date for assessing infringement of those marks following Supreme Pet Foods is the date of registration of those marks, so it would be 2015 and 2017. This feeds into my point that it must be a continual assessment. It's not an assessment that is made at one particular fixed point in time, being the date the use complained of commenced or the date that the later marks were registered. And that's because the doctrine focuses on the way the guarantee provided by the mark has altered, which happens over time as a result of the concurrent use. And so that is why, in my submission, it's appropriate to consider the entire period of trading up until the claim form.
Well, I understand the submission that you may have to reassess as at different dates. I mean, we know that infringement assessments can change if, for example, the nature or context of the use of the sign changes, see BDO. But, and in the present case, as I pointed out, you can well say that there's a need for a reassessment as at March 2015 and again as of January 2017. But I'm not sure that there's any case law to support the idea of a continuous assessment, is there?
No, my lord, this is not a point, as far as I'm aware, that has been considered in the cases before. Now, it might be because the focus on the relevant date for the purposes of infringement has become much more usual in recent years. So in IPC, for example, which was in 2009, I don't believe the court identified what the relevant date was, but that is always done now in all of these infringement cases. It might be that it hasn't been grappled with by the courts before because no court has considered that the infringing use has to be non-infringing from the start, and so the point simply hasn't arisen. But that is where we are, and it's a point that I will be inviting this court to grapple with.
Thank you.
So I've identified the judge's first error and explained why, as a matter of law, that was a mistake. His second error was in considering that the honest concurrent use had to start before the marks were registered. And my lords can see this from the second sentence of paragraph 141 and his reference to Match's prior registered mark. And in my submission, this is simply not a requirement of honest concurrent use, because the critical requirement of use in a way that alters the guarantee given by the mark is not dependent on the honest concurrent user starting before the mark is registered. I've referred in my skeleton to 3 cases which demonstrate in a roundabout way that this is not part of the test, because again, this is not a point, as far as I'm aware, that has been expressly decided, but the 3 cases that I have referred to were dealt with on the basis that, well, this was not a factor that was taken into account, even though those cases involved concurrent use that started after the marks were registered. Of course, IPC itself, the mark was registered as of 2006, but the use complained of, which was the launch of the online shop, was in May 2012. Now, although it's fair to say in that case, the court didn't consider that to be a material change in circumstance, so they took into account all of the other earlier use. There was no reference to the fact that the use complained of started after the mark was registered. It's just something that isn't taken into account. And that is because it's simply not a requirement of honest concurrent use that the use commences prior to registration of the mark. My third topic is the effect of these two errors. And I have slightly touched on this in response to my Lord's interventions. But just to summarise, the effect of these two errors is that the judge didn't consider the critical question, which was what effect, if any, the period of coexistence had had on the functions of the marks. And it's very clear from the judgment that he did not consider the continuing use because he was making an assessment as of 2011. And in my submission, had he done so, he would have found that there was no adverse effect on the functions of the marks for the following reasons. The two businesses had coexisted for over 10 years. I've already dealt with the scale of use when I addressed the court on the absence of evidence of confusion. In my submission, that use resulted in a process of education of the public. Now, the judge possibly hinted at this in paragraph 141, where he said the very reason why use infringes is because if left unchecked, its effect would be to educate the public that the mark does not indicate the services of the trademark proprietor. Would have been more accurate to have said solely indicate the services of the trademark proprietor. But in my submission, that's exactly what did happen here. But because the judge was considering that the use had to be non-infringing from the outset, he didn't appreciate that.
And to be clear, as I understand it, your submission really does involve this proposition, that it's the claimant's fault because they could and should have sued earlier. I mean, in theory, if they'd become aware of your clients, their evidence was they weren't, but in theory, they could have sued on day 1, 2011, because they had their first registration on the register at that point in time.
Well, they could have done. I don't go so far as to say this is all their fault. What I do say is that they can hardly complain if, as a result of the concurrent use and the coexistence, the functions of their mark have been altered such that they can no longer restrain my client by way of injunctive relief. And I also say there is nothing inherently unfair.
So rather than fault, it comes to this, that the circumstances have changed as time has passed.
Indeed. My last point on this is that although it's not a requirement of the doctrine of honest concurrent use that the relevant public has learnt to distinguish between the two trademarks, where that happens, the case for honest concurrent use must be even stronger. And in my submission, that is what the evidence showed in this case, because there was no evidence of confusion at all, not even a small amount of confusion, as in IPC. And I pray and aid my earlier submissions on the absence of any evidence of actual confusion. Now, doubtless, the period of use had contributed to that, it's probably also the case that the distinguishing factors played a part. And by that I'm referring to the targeting of the Muslim community by the appellants versus the non-targeting of any class or type of person by the respondent. And those, of course, are differences in context, matters that are extraneous to the mark itself, as in Budweiser, but also the differences between the marks. So the .com element of the registered mark, the figurative element of the match mark, and then the additional elements of the appellant signs, including Muz and the butterfly and other figurative elements. And those differences are important, particularly where the point of similarity, match, is a word that is used in this industry in a descriptive sense, even though it's used by the parties distinctively. So those differences between the marks I've referred to as identifiers in my skeleton, and I've referenced the McAlpine case where there were identifiers too. So in the absence of confusion and an effect on the origin function, it's hard to see how there is any effect on any of the other functions either. Accordingly, the judge ought to have found that there was no effect on the functions of the marks as a result of the honest concurrent use by the appellants. I'm going to move on to the final topic, which is honesty, unless my lords have any questions.
No, thank you.
On honesty, in paragraph 139 of the judgment, the judge did refer to paragraph 79 of Victoria Plumb, which is where the test for honesty in the context of honest concurrent use is set out, but he didn't cite the relevant principles, and he didn't make any express findings on this point. My learned friend relies upon Cipriani and Sam Smith for the principles relevant to honesty, but those, of course, were cases that considered the principles in the context of specific statutory defences. And in my submission, it's not helpful to look at the case law on honesty in that context, because the doctrine of honest concurrent use focuses on the effect of coexistence, with the result that inevitable confusion may have to be tolerated. And that is why, in Victoria Plumb, the judge held that the factors which have been considered in the context of the statutory defences required a degree of adaptation when considering whether concurrent use is honest. And we can see that in paragraph 79 of his judgment, which is in volume 2, behind tab 25. On page 719. The judge identified 5 factors in considering whether concurrent use is honest. Could I just ask my lords to read those 5 factors? So the key question is whether the defendant has taken steps which exacerbate the level of confusion beyond that which is inevitable, and so has encroached upon the claimant's goodwill. Had the judge considered these relevant factors, then based on his other primary findings of fact, he would have found that the appellant's use was honest. I rely in particular on 8 points. Firstly, the judge accepted Mr. Craig's evidence that he was not aware of the respondents when the name Muzmatch came to be chosen. That's paragraph 49 of the judgment. In the same paragraph, the judge referred to Mr. Eunice's evidence that he chose the name because it carried a clear and simple message, a service that helped users find a Muslim match. And the judge found that Mr. Eunice was a straightforward and honest witness, doing his best to assist the court. Thirdly, the judge accepted in paragraph 141 Mr. Eunice's evidence that he did not intend to create a link or cause confusion with the match marks. Fourthly, the judge also accepted Mr. Eunice's evidence that in creating his list of keywords, he did not think about Match.com or the match group. That's paragraph 58 of the judgment.
Yeah, can you help me on that aspect? Because this is something that puzzles me about this case. Because one way of looking at this case is that actually the claimants were running 2 distinct infringement cases. One was what one might call the general case of infringement through use of the sign, and the other was a specific complaint about the use of the keywords.
Yes.
And conceptually, it seems to me, it would have been entirely possible for the claimants to have failed on the general case and yet still succeeded on the specific case about the use of the keywords. And yet, the judge's approach seems to be, and it may be because this is the way the case was argued before him, to treat the specific case as simply a subset of the general case, or an evidential aspect of the general case, perhaps, is a more accurate way of putting it. And what do you say about that?
Well, I'm not sure, with respect, that it's right to say that if the main case hadn't succeeded, the keyword case could have succeeded. Because, of course, there's nothing inherently objectionable about the use of keywords. The issue is whether what is displayed as a result enables consumers to distinguish between the trademark proprietor and the third party.
Bearing in mind the keyword that the user has used.
Yes, and in this case, the defendants did not use the claimant's marks as a keyword. They didn't use match at all. They didn't use match.com. They used combinations like Muslim match, match marriage, sometimes with the name of a country. So Afghanistan, Muslim match, and claimants didn't have any presence in Afghanistan. So the critical issue is what was displayed as a result of that search, and the judge found that it's likely that the link contained the name Muzmatch, and there is an example of the landing page reproduced at paragraph 60 of the judgment, and the court will be able to see from that the use of Muzmatch on that. So in circumstances where the use of Muzmatch doesn't infringe because it doesn't cause confusion or a link, in those circumstances, the use of the keywords would also not infringe.
So I think that was your fourth, which means there must be one or two more to go.
Yes, I'm afraid so. Does that answer my Lord Justice Arnold's question?
It certainly goes some way towards it, thank you.
So my fifth point is that Mr. Eunice's evidence was that he'd never come across any instances of Muzmatch members being confused. Sixthly, from the summary of use given by the judge at paragraphs 55 to 56 of his judgment, the court can see that the appellant's business grew organically since 2011, steadily increasing its numbers of users. Seventhly, the parties...
Well, just on that point, a point is made in the respondent skeleton about, this is not quite how they put it, but using my own words, they say there's a disjunction between earlier use by reference to the website and later use by reference to the app.
Yes, that's a point that's made in their respondent's notice. It is a completely hopeless point for the reasons that I will explain when I come on to deal with that.
Oh, fine. Okay, thank you.
So the seventh point is that the parties' businesses have at all times had a very different focus, with the appellant's business always focusing on Muslims finding a marriage partner, and the respondent's business not being specifically targeted at anyone, any particular type of person. And importantly, on that point, at paragraph 46, the judge rejected the respondent's case that Muzmatch might seek, or might already be seeking, to attract non-Muslim customers, and so broadening its target audience. That goes to encroachment. There was none here. The eighth and final point is that far from taking steps to exacerbate any confusion, the appellants had at times taken steps to move away from the respondents. And I'm here referring to the evidence of Mr. Eunice that in 2016, the appellants redesigned their entire logo in response to complaints from the respondents. My lords, could I ask you to take out bundle S and just have a look at this evidence? It's behind tab 5 on page 71. At paragraph 147. Mr. Eunice is referring to settlement discussions that took place following the claimant's letter of complaint in January 2016. And he refers in particular to an email from the legal affairs manager for the respondents, dated the 23rd of March 2016, where she says, "We understand that you've been operating Muzmatch for some time, and that the domain name match.com was registered in April 2011. Because of this, we're prepared to tolerate the ongoing use of Muzmatch in Europe and the US, subject to a further conversation around the exact branding style." And then paragraph 148, Mr. Eunice's evidence is that he understood that to mean that their concern was not about the word Muzmatch at all, but about the branding elements that went with it. And then over the page at 152, paragraph 152, as a result, he changed the branding style to include Muzmatch in characters with the butterfly. And that is the branding that was used until 2020, with no further complaint by the respondents. My lords, in paragraph 182 of the judgment, the judge found that the evidence did not show a general tendency by the appellants to follow or ape the respondent's branding. This also goes to encroachment. There was none here.
Could we have that paragraph number again? Because
128.
128. I think you said 182, unless I misheard.
I apologise.
Yes, you did. Okay.
128 of the judgment. So based on those findings, the learned judge ought to have concluded that the appellant's use was honest. That brings me on to the respondent's notice, where the respondents rely upon 4 points to say that the use wasn't honest. The first is Tinder, and they say that the court should take into account the admitted infringement of the Tinder marks when assessing the honesty of the conduct of the appellants in relation to the marks in issue. Now, I've already addressed the court on the appropriate test for honesty, but even when considering statutory defences, there is no requirement for the defendant to submit to an open-ended assessment of his commercial morality. The focus of the inquiry is whether the defendant has acted fairly in relation to the trademark owner. The reference for no open-ended assessment is Sam Smith, paragraphs 119 to 120.
Not that I originated that statement.
It is implicit in that it relates to the trademarks in issue. Now, I accept that TRIPS allows exceptions to be made to rights conferred by a trademark, and the interest of the owner of the trademark is taken into account. But that must be in relation to the trademark in issue, namely the trademark whose rights are being limited by the exception. In my submission, the appellant's conduct in relation to different marks is just irrelevant to the question of whether they acted fairly in relation to the interests the respondents have in the match marks. The second point that is made is that the appellants were aware that the respondents objected to the use of Muzmatch per se in the light of the successful opposition, which was in February 2016, and the letter of complaint in January 2016. The opposition has no impact at all on the use of the sign Muzmatch by the appellants, and that is because registration of a mark confers no positive right to use it as a trademark. Rather, it is an exclusionary right to prevent others from using it. As for the
well, there's recent authority of this court to support that proposition. But while the broad statement is correct, is it not relevant to the question of whether you know that the trademark owner is objecting?
Well, my lord, if it is relevant, then it needs to be put into context. And the context is that during that period, the respondents indicated to the appellants that they were prepared to tolerate the ongoing use of Muzmatch, subject to a further conversation around the branding style. And I've just taken the court to that evidence. And Mr. Eunice's evidence was that he took this to mean, understandably, that their concern was not with the word Muzmatch at all, but with the branding. So if it's relevant, my lord, then that evidence answers the point. The third point that is relied on is encroachment, and it's said that the appellants have encroached in two ways. Firstly, that they've moved from a website to a mobile app, which amounted to a change in the appellant's business. Now, in the light of the judge's findings, that point cannot succeed. In particular, at paragraph 45 of the judgment, the judge found that once the app was launched, the website was retained to promote Muzmatch services, that visitors to it were directed to the app. And then he found that the appellant's focus continued to be to provide a service targeted at Muslims to find a marriage partner. At paragraph 46, the judge found that Mr. Eunice was not seeking to broaden its target audience, and there is no cross-appeal against those findings, nor do the respondents identify how moving the same business from a website to an app amounts to a material change in that business. The second way it is said that the appellants encroached is the rebranding exercise, and in particular the change to the logo in 2016, but then the return in 2020 to one of the earlier logos. And it said that this was a continuation of the appellant's earlier strategy of operating as close as possible to the style of the respondent's marks. And the judge found on the facts that the evidence did not show a general tendency by Muzmatch to follow or ape Match's branding beyond the use of the Match name. That's paragraph 128. And there is no cross appeal against that finding. So that is simply not a point that is open to my learned friend.
Yes, but can you help us on this? I mean, you've explained how the logo was changed in 2016 in response to the complaint. But then it was, as I think you accept, changed again in 2020. So why? Perhaps more to the point, what were the judge's findings about that particular aspect?
Well, the evidence was that it was changed back to the lowercase font because Mr. Eunice felt that using uppercase was a bit shouty.
So that was in 2020?
That was in 2020. My lords can see the way the logos evolved on page 106 of the bundle, paragraph 53. So in row 10, my lords can see that the butterfly device was introduced and the uppercase Muzmatch. And then in 2020, row 12, the font changed to lowercase, but the butterfly was retained. The heart, the use of the heart, the last use of that was February 2016, although my lords may have picked up from the judgment that in fact it was the appellants that used a heart device before the respondents ever did. Now, I am not sure that the judge made express findings as to the reason why Mr. Yunus went back to lowercase in 2020. But certainly the evidence was that he found the uppercase a bit shouty. But the judge did make a finding that there was no attempt to ape the respondent's branding. Quite aside from that, it's not entirely clear how this advances matters for the respondents in any event, because if the earlier strategy wasn't honest, then there's no honest concurrent use. But if the earlier strategy was honest, then returning to that strategy in 2020 must also have been honest.
Does that follow? By 2020, Mr. Yunus is aware that there's objection to the branding. He moves away from it in 2016. Does it necessarily follow that moving back to it in 2020 must have been honest just because it was honest before 2016?
Well, I thought it followed, yes.
The circumstances might be different. I mean, I have your point that the judge... Where does the judge say that he wasn't aping the...
Paragraph 128.
Thank you.
It's about halfway down that paragraph. And he refers to the detailed evidence that Mr. Yunus gave. A third point is raised on encroachment, which is in my learned friend's skeleton, but not in the respondent's notice. And that is that the appellants filed a trademark application which was not limited to specialist or Muslim dating, which evidences an intention to develop a product that went beyond the Muslim market. But my lords have my submission that the judge found Mr. Yunus was not seeking to broaden the target audience in paragraph 46, and there's no cross appeal against that. Moving away from encroachment, there is one final point that is made in my learned friend's skeleton, but again not contained in the respondent's notice, and that is that there is no evidence that the appellants carried out a trademark search. That's paragraph 78 of my friend's skeleton. The starting point is that, as the court held in Walton Stores at paragraph 214, a mere failure to carry out a search is not sufficient to deprive a defendant of an honest concurrent use defence. If it were, then the defence would be very rarely available.
Yes, but a different view was taken by Judge Haycon in, was it Bentley?
It was, my lord, and I would invite this court to follow Walton. In the circumstances...
Do we have
this
that in the
case,
bundles?
Yes, it's in the bundles.
Could you just remind me?
Yes, Walton is in volume 2, behind tab 26. And Bentley is in volume 1.
Shall we look at those passages briefly?
Yes. It's paragraph 214 of Walton. Which is on page 799.
Yes.
So it's the second sentence, and then at the end of that paragraph, as Mr. Justice Carr held in Victoria Plum, the key question is whether the defendant has taken steps which exacerbate the level of confusion beyond that which is inevitable, and so has encroached upon the claimant's goodwill.
Bentley.
Bentley is volume 1, tab 6. Actually, it's not Bentley, my lord, it's GNAT, which is behind tab 13.
My fault, sorry.
Volume 1, and it's at paragraph 86 of that judgment. And as part of His Honour Judge Haycon's reasoning in paragraph 86, he referred to what the judge in Victoria Plum said, and he said in that case Henry Carjay apparently agreed with the factors set out in Cipriani and said expressly that all relevant matters must be taken into account. And of course,
but it would be quite a strange proposition to suggest that relevant factors shouldn't be taken into account.
Indeed.
And I do wonder, with respect, whether many of these dicta need to be read in the light of the facts of the cases before them, and we're classically in the territory of factual findings which lead to an evaluative judgment.
Indeed.
Anyway.
Well, if we look at the facts in this case and the circumstances of this particular case, it's very difficult to see how the absence of a trademark search could affect the honesty of the appellant's conduct, because had the appellants conducted a trademark search in 2011, they would have identified the first Match.com mark, but that would have revealed no more than the appellants already knew. That is to say that the respondents ran an online dating service called Match.com. The appellants believed that their business was sufficiently distinct because of the targeting of the Muslim community. And over the years that followed, they continued to develop that business without in any way changing the essential nature of their business or expanding into mainstream dating or otherwise encroaching upon the respondents. And during that entire period, the appellants have never encountered any problems in the marketplace. There's been no confusion in practice. So in those circumstances, the failure to carry out a search is not, in my submission, sufficient for a finding that the appellants did not act honestly. That brings me to the end of my submissions. So unless your lordships have any questions for me.
No, thank you very much indeed, Ms. Bergman.
I'm grateful.
Mr. Austin.
Thank you, my lord. Firstly, I think it would be helpful to start with some critical findings that were made at trial, with which my lords are not to be troubled today. No appeal was pursued or no permission was granted as to the following. All the relevant dates, where the match solus was used in a distinctive sense, it designated the services of the respondents, and that was at paragraph 11 of the judgment, and that by 2011 the respondents had acquired a very substantial goodwill in that word as its brand. That's at 144 judgment. The word match was was the dominant element in each of the match marks asserted. And by 2011, the earliest of those marks had acquired a very substantial degree of distinctiveness and reputation as a brand. Judgment, paragraph 93. The judge also held that later on, when the further match marks were filed, they rapidly acquired their own distinctiveness and reputation after that filing date. And that was at paragraph 111 of the judgment. And further, that extended to the Muslim community. So the marks, further, what is not obvious is that the marks, when compared to the appellant's signs, had a medium degree of similarity, paragraph 87 of the judgment, and they were used for admittedly identical services. Against that backdrop, there are essentially three questions for my lords to decide. Did the judge err in making his global assessment under section 10.2 in a manner that makes his finding that there was a likelihood of confusion between Muzmatch and the Respondent's trademarks rationally unsupportable? Secondly, did the judge similarly err in his assessment, leading to his finding that consumers would make a link between Muzmatch and the claimant's trademarks? My learned friend contends that those two grounds are one and the same, and she hasn't dealt with it. But we say that's not the extent of the permission that was granted to my learned friend to appeal today. The issue was to the extent the grounds replicate the finding of link under section 10.3, and we say it's a different analysis. I'll come back to that point. And thirdly, did the judge err in law in rejecting the defence of honest concurrent use?
So rejecting the defence of?
Defence of honest concurrent use.
Thank you. Sorry, I'm losing the end of your sentences.
I'm probably mumbling. The assessment of passing off we accept essentially stands or falls with the assessment of confusion. So with that in mind, Lords, and if I may say so, what has been slightly lacking from my learned friend's appeal so far is some time on the factual background to this dispute. It may be hard to remember a time before online dating, but this way of meeting new people really has a long and astonishing history. The my client's online dating service, which was originally at a website found at match.com, was launched in 1995. That was at paragraph 17 of Mr. Riviere's evidence. Supplementary bundle, tab 10, page 123. The match dating service for match.com wasn't the first, but it was one of the first big ones. And the founders of this dating service were ahead of the game. They used the power of the internet to allow users to reach people, far more people than classifieds or advertisements or meeting in public places could do. And such a service could be particularly useful for those whose potential partners might be on the other side of the country, or indeed the world, or had specific requirements, or where the pool of candidates was small. Now, of course, the key to an online dating service is to generate a critical mass of users, so the service is recognised by consumers as being potentially useful to identify a number of suitable partners. So in that sense, any successful online dating service is self-perpetuating in that people would know that a service already had a large number of subscribers and therefore would be more encouraged to join it. Another factor in evidence before the court in encouraging new users was trust. That was covered by Mr. Lubo, paragraphs 13 to 14 of his evidence, which is a supplementary bundle, tab 15, page 209. Users needed to know that their personal information was safe and they could control the publicity of their identity and information. And finally, in evidence before the judge at trial, there was the initial stigma behind online dating. That was addressed by Mr. Riviere, paragraph 36 of his evidence, supplementary bundle, tab 10, 136. At the outset, there was a sense that meeting online was second best to meeting in person. Those days are long gone, but thanks to the huge investment and effort made by my clients and others in the vanguard of this field to make online dating more accepted across society. And that was in evidence before the judge as to the extent to which my clients had put out TV advertisements on billboards and the like to promote the service, but also to widen access of online dating to the public at large. Now, if we turn to the online dating market at the relevant dates, at the relevant dates, quite a few online services already had substantial public recognition in this way. And the identity of these services were before the judge at trial as part of my client's contemporaneous market research reports, brand tracking reports, as my client referred to them, and every one of those reports from 2011 to 2017 showed Match, or Match.com, as the clear market leader. The relevant dates in this case are not appealed. The judge dealt with those, and my lords have seen that at paragraph 77 of the judgment. And so the date for assessment of infringement is March 2011, which is the date that the Muzmatch website was launched.
For the first mark.
Of the first mark, indeed, my lord. And then the filing dates of the subsequent match marks. The brand tracking reports I've just referred to are confidential. But Mr. Riviere explained in evidence, and this is at paragraph 19 of his statement, supplementary bundle, tab 10, 124, that the main brands in 2011 known to UK consumers were Match, eHarmony, Plenty of Fish, Match Affinity, as well as smaller brands such as Zeusk, Uniform Dating, and My Single Friend. The brand tracking report in 2012 also identified further smaller brands on the market at the time: Friends Reunited Dating, Badoo, Guardian Soulmates, Christian Mingle, and Shardy. Those last two might be regarded as more specialist for Christian users or those of Indian heritage, respectively. But the number one and most known dating brand in the UK in 2011 was Match. This had the best top-of-mind awareness, 28%. And what that means is that when a user, or a single, as I think they're called, was invited to name an online dating service spontaneously in an unaided way, that was the first one they named. The second best service was eHarmony with 7%. And indeed, these statistics increased in Match's favour after 2011, as high as 47% in 2014. If my lords just want to see that, it's tab 10 of the supplementary bundle.
Well, don't we have the findings by the judge?
I think the judge summarised all of it,
He did.
starting at about 27 or maybe a little earlier. And we've got a useful table at 35, I think.
That's right. None of this is challenged, of course, and quite understandably, because Match was the dating service, online dating service in people's minds. 1 in 3 British singles spontaneously mentioning Match first. And the judge, of course, at 110 of the judgment, was right. Match had a very significant reputation in that it was clearly known by a very substantial part of the public concerned with such services, and was in fact the dominant force in the market. And as that table shows, this had been the case from at least 2009 and continued until 2018. After 2018, the Tinder service, which was also one of my clients, took over for top-of-mind awareness, although Match has remained near the top since then. Tinder is well known for its Caddick style app, where you're presented with profiles of users for filtering. And I'll come back to the marks, the Tinder marks, which were an issue briefly in these proceedings. As I've said, the court heard extensive evidence of TV advertising, social media presence, and resultant website traffic across the UK and Europe in relation to Match. And just to give an idea of numbers, by 2004, my client service already had 12 million active members worldwide. And in 2011, there were approximately 129,000 subscribers and sales in excess of 29 million euros. In October 2015, Match had 505,875 monthly active users in the UK alone. And in my submission, and the judge accepted, the statistics in respect of this service were impressive. Now, Match can be used as a descriptive word, but as the judge rightly found, in 2011, 2015 and 2017, when used as a distinctive word in the context of online dating services, it meant the respondent. Match just meant match, and that was at 93 little c to e of the judgment. At all times, the Match service was regarded as suitable for users seeking serious long-term relationships. And this is in contrast perhaps to Tinder nowadays, which takes a more relaxed and fun approach to the filtering and dating process. Match is also, like Tinder, described as a generalist service. In other words, it is open to and targets all types of users. This does not mean that you cannot narrow your preferences to any particular set of values, religion, culture, or occupation on Match. You can. In fact, that's the whole point of the online service. You can find someone suitable and appropriate to your set of values or your beliefs, whatever other criterion you care to specify. And that was the evidence given by Mr. Riviere. Match caters for all age ranges, backgrounds, and religions. And religion had been an optional profile question and search criterion since at least 2011. So Muslim users could meet other Muslim users if they so wish. Indeed, the evidence before the court was that the Match service in the UK had a significant number of registrations by users stating Muslim as their religion, between 2 and 3.4% of users who filled in that religion question. And since that question was optional, that was likely to be an underestimate of the actual number of Muslim users. Just moving quickly on to the match marks. The Lords have seen they're registered, originally the 1996 match mark was registered for match.com, and it was common ground, although it was registered for information and consultancy services in the nature and field of online dating introduction services, common ground that covers online dating introduction services. The match device, and Lords, these are all set out at paragraph 4 of the judgment, and that's the match device with a heart in the top right. That was filed in March 2015 for, amongst other things, provision of dating agency services via the internet. As Mr. Riviere explained in the trial, this was filed around the same time that the match service was moving across from a website accessed through a browser to an app accessed on a mobile phone. In other words, whilst there had been use of both Match and Match.com in relation to the website service, from 2015 my clients traded only as Match, and also in the form of that device as registered. Respondents have also relied on the 2017 Match.com mark. Services in respect of that are slightly different, but nonetheless we say nothing is added other than the difference as to the date for assessment of infringement, which I'll come back to. Quite sensibly, Muzmatch must have recognised in this litigation that it had been a hopeless endeavour to challenge the validity of the match marks, given the huge reputation invested in them, resulting in the high level of distinctiveness. Since there was no challenge, that means that the court must assume that the match marks are validly registered across the breadth of their specification. Now, of course, when it comes to infringement, the court must approach that assessment from the point of view of the notional and fair use of the mark in relation to all of the goods and services, which in this case are mostly services, in respect of which it is registered. And that's set out helpfully by the Court of Appeal in Meyer and Assos, paragraph 78. And I don't think it's necessary to go to it, but that's at tab 18, page 451 of the authorities book. As I've said, there's no doubt that match has a plain English meaning. But at all material times this litigation, match, when used as a trademark, signified to a very large number of consumers the online introductions business of my client. So instead, the appellant sought to exploit this in a slightly different way, by contention that the users would not see the term Muzmatch as alluding in any way to the famous Match brand, but to the descriptive alternative meaning. And this was said to be particularly so with respect to Muslim users, and also that the founder of Muzmatch did not have the world-famous match service of my clients in mind when devising the name of his online dating website in around 2011. He just considered a plain English reference. So, to counter the case run by my clients, they contended there was no intention on the part of Mr. Yunus. Now, as explained in my introduction, the first of these two arguments failed, and there's no appeal. I'll come back to these points shortly. I was just going to turn briefly to the Muzmatch service, my lords, but I noticed the time.
Well, shall we return to that then at 2 o'clock?
Okay.
Look forward to hearing you then.
All rise.